Good afternoon, Professor. We are Group 7 and we choose topic 4 for our presentation. To begin with, I will analyze Lord Hoffman's viewpoints. Firstly, I will brief Lord Hoffman's view to introduce the concept of coming. Lord Hoffman in the HIH claimed that traditional place of incorporation test is not the best one, and the coming test is more appropriate because sometimes the company may be incorporated in an offshore island, and there may be no real connection between the company and the island. What Lord Hoffman has suggested is that at common law, the English court might recognize foreign insolvency proceedings where a corporate debtor had its common, but not where it was incorporated. Secondly, I will analyze the aims and factors of common. Place of incorporation may be an accident of many factors and may be far from the actual place of business, while common test is different. It may include the location of debtor's headquarters, the location of those who manage the debtor, like a holding company's headquarters, and many others. Thus, the common test has more links with the real situation of the company and provide more help with creditors than place of incorporation. Thirdly, what's the intention behind Lord Hoffman's view is to introduce a modern approach into common law. Lord Hoffman is trying to put forward the boundaries of common law creativity in the sphere cross-border insolvency. Despite that his exploration is rejected by the majority, it is a trend in the future. The intention behind his viewpoint can be decided in the case of Cambridge. First, the insolvency proceeding does not fall into either in personam or in rem and should be subjected to a different rule. Second, the English common law was traditionally taken the view that fairness between creditors requires that, ideally, insolvency proceedings should have universal application. Therefore, what Lord Hoffman hopes to achieve in the future is a single or at least uniform insolvency regime, which promotes fairness among creditors, increases the efficiency and consistency of courts, and finally eliminates the phenomenon of foreign shopping.
In this part, I will analyze Lord Collins' viewpoint. How Lord Collins refuted Lord Hoffman can be summarized into three main reasons. The first one, the traditional common law rules should not be rejected, and this point can be illustrated through two aspects. The first aspect, actually prior to this case and a former case called Cambridge Gas, there had been no suggestion that there should be a different rule for recognition and enforcement of judgments in foreign insolvency proceedings. However, in present case, the majority of the Supreme Court held that the Cambridge Gas was wrongly decided, so it was not followed in this case. The second aspect, if there is to be a different rule, the court will have to ascertain two jurisdictional rules to test the new rule. In present case, the respondents tried to establish their sufficient connection with U.S. by only applying what Lord Hoffman said in the case HIH Coyote. However, Lord Collins refused their proposal and said the common law rule in recognition and enforcement of foreign judgments is a black letter rule. A black letter rule means it's generally known and free from doubt or dispute. The second reason, if there is a change to the settled law of this area, it should be for the legislature to decide and not for the discretion of judge-made law. Lord Collins also cited what Lord Bridge said in the case Owen Bank to support his point. The third reason, there is not likely to be any serious injustice if this court declines to sanction a departure from the traditional rule. So the question is, what is the impact of Eurofinance? In truth, Lord Hoffman attempted to develop common law by craving the insolvency proceeding out of original rule in recognition and the enforcement of foreign judgments. However, his attempt was rejected in Eurofinance. So for the law relating to the international insolvency, it should reverse back to what we call well-established common law rules. And for the petitioners, It is not enough that a foreign insolvency court has internationally recognized the jurisdiction through the test like COMI. And in UK, the court's power to give effect to foreign insolvency court order will only arise where the traditional common law rules are satisfied.
Hi, my partner just explained the case itself with some basic facts. I'm going to do some further explanation of the Darcy rule and the two nexus under the common law in relation to the insolvency issue. The first thing is that if you want to enforce a foreign judgment against the UK residents in insolvency law, you have to be satisfying the Darcy rule of one of the conditions. But in this case, the UK residents has not surrendered themselves to the jurisdiction, nor they have participated in the proceedings of the US insolvency. So if they were to apply the Darcy rule, there will be no enforcement in the UK. So they're trying to establish a separate rule, which is not the Darcy rule, but it's still under the common law, saying the first ground is that there's a real and substantial connection between the UK residents and the TCT trust, so they have to be recognized and enforcement has to be given. But this idea was rejected because this analysis of real and substantial connection was only used in the UK in relation to the matrimonial stuff and the divorce case. Then they secondly saying that the US receiver saying that the warden's claim should be different from normal claims under the insolvency law. So they have to be a separate rule for which is not the Darcy rule. This idea was also rejected because the court sees no difference in the substance that a warden's claim is different from normal claims. They further agreed that even there is a separate rule under the common law, they still have to satisfy two conditions, which is the two connections, two nexus, also to say. The first thing is the connection between the judgment debtor and the foreign court. The second thing is the connection between the insolvency and the foreign court. They agree that both the court and the receiver agree that the traditional approach of the connection between insolvency and foreign court is the place of incorporation test. Then they trying to refer to the Hoffman in the HRH case, saying that the modern test is the COMI test to prove such connection. This was also rejected for some reasons which my partners talked about, and I see the outcome here that if you were to change the common law rule, then the outcome will just see outcomes that the competent jurisdiction under the common law will be eventually the same under all four regimes, including in UK law, EU law, the 2006 regulation. There will be no difference, and there's nothing left to reflect domestic insolvency policy. And the second thing is reciprocity, because the court sees no benefit because of the uncertainty of the reciprocity. Even if you recognize or give enforcement the foreign judgment on this issue, they won't do the same. So that's my analysis of this case, and I will pass it on to my partners for further analysis.
The second point that's supporting Colin is that the uncertainty of COMI's definition will cause many problems. While COMI is stipulated in many regulations, there is no uniformly specific definition of COMI, causing judicial practice of deciding COMI varies tremendously. I will further explain in the following two scenarios. The COMI concept has different functional significance in the model law and the EIR. Under the EIR, the COMI concept controls the jurisdiction that open insolvency proceedings, whereas under the model law, the COMI concept merely determines the nature of the foreign insolvency proceedings for recognition purposes. We could ascertain the difference from the specific legislative wording in the recast EU regulation and the USA Chapter 15. Instead of providing for presumption in the absence of proof in the recast EU regulation, the equivalent provision in Chapter 15 provides for the presumption in the absence of evidence to the contrary. Thus, additionally, with the pursuit of certainty, ECJ traditionally gave COMI presumption a significant weight. However, courts in USA weight all aspects of an insolvent company to justify recognition. After the Brexit, UK made departure from EIR path and get closer to the model law path, which needs more guidance from legislation that able to reflect the change. Even by applying the model law, the different implementation with judges' own discretion may result to common problem. For example, the articles in the model law do not directly address the problem that the relevant time in deciding common. The revision guide posted in 2012 makes it clear that the relevant date is the date of commencement. However, the dominant judicial view in USA prefer the time of application. In the Fairfield case, the Second Circuit endorsed the majority approach, solidifying the time of filing under the Chapter 15. However, in Millennium case, the court rejected the majority approach to consider commi as of the date of commencement of relevant foreign proceeding. Accordingly, even in the same country, the court referred to revised guide may determine different commi from those who holds the contrary views. Definition of commi is more complicated when a multinational corporate involved. The subsidiaries are incorporated in different countries, but all under the same control of a common entity. In conclusion, commi's vague definition indeed caused departure from its original purpose, despite attempts to create a more universal system of insolvency resolution. Significant national differences remain. Even commi needs to be applied in recognition of foreign insolvency judgment in UK. It should be amended to promote its enforceability.
Since common law rules has provided assistance with foreign courts on insolvency for a long history, whether the common law should embrace this modern approach, I will give a negative answer, and following are reasons. Firstly, CBIR 2006 is just a supplement of common law. The UK provides 4 sources of assistance relating to insolvency proceedings. Common law rules still plays a significant role on insolvency issues because of the limited application of EC and 1986 Act. As regards CBIR 2006, it do shows a purpose of applying a modern approach to better cooperate with other countries and provides a straightforward recognition process. However, in practice, it lacks of expensive relief. What's more, since any third country can access to UK as long as they satisfy the criteria, judges worry that they cannot provide equal protection between countries with well-established insolvency law and those without. So, the model law never supersedes the common law, but only supplementing it. Secondly, judge discretion would make the definition of commi vaguer. As my partner has stated in previous part, the regime behind commi has not developed to a mature one, which judge can directly apply. Judge discretion on this definition would cause more ambiguity while applying this approach. Thus, it comes to my third reason. Embracing of commi cannot be achieved just by a dictum of Lord Hoffman, nor by a judgment-made law. It is only a dictum of Lord Hoffman and is not legally binding. What's more, it is true that the common law provides a flexible approach to accomplish the purpose of modified universalism. However, there are other factors should be considered. Firstly, uncertainty would arise if the inherent power of court is incapable of incremental development. But there is no way to knowing the extent of such a development with any certainty. Secondly, it is absolutely unrealistic to wholly embrace the universalism, considering a state would have a natural inclination to the preference of its own insolvency law. Also, since the modern approach of recognition conflicts with common law rules, it cannot be perfectly solved just by introducing a new rule to common law. Instead, it should have more precise statutory law to better solve this problem. Thirdly, behind commi, there has a large series of rules which constitutes a modern regime. If UK tends to establish an entirely different regime out of existing rules, it is the job of legislature instead of judicial power. After all, the role of court is indeed a decision maker instead of a regime creator. Here come to our conclusion. We do not accept introduce modern approach into common law to overturn traditional common law. We do not accept introduce modern approach into common law to overturn traditional common law rule. If there is a need to step forward to do so, it should be achieved by legislation, Thank you. That's all.